99% of the self-defense cases that prosecutors see, that judges see come into a courtroom, they're bad guy cases of self-defense. So when you walk in and you're claiming self-defense, they immediately presume that you're in that category too. Why wouldn't they? We often encounter, in my practice, prosecutors are just shocked at the kind of defense that they're getting in a self-defense case because they're not accustomed to seeing that at all.
Hi, Culminators. Thank you so much for joining us. The beauty of Andrew Branca is that his content and what he has to say is timeless. This is my friend, Andrew Branca. I do think he is the only person I've ever had on the show who once blocked me. And that's one of the things that brings us together.
That's true. That's true.
I was probably just being snarky about something. I'm sure I had it coming. Andrew was the man. Although if you read his materials, you'll see that he recognizes many other men who inspired him and taught him, but he is the man on the internet for law of self-defense. Our mission, make you hard to convict. He's going to tell us why that's the mission. Andrew, how you doing, you lawyer, you?
I'm living large, man. Life is good. How about yourself?
You seem to be kind of loosening up. You're in shirt sleeves.
Shirt sleeves? Oh, you mean I don't have the jacket on?
Yeah.
Yeah, we have our studio has like a desk for formal stuff, and then this is my work desk with the webcam. So when I'm on the other desk, I wear the jacket. When I'm here, I just wear the tie. Sometimes not even the tie. Then things get really crazy. Oh my gosh.
So Andrew and I first encountered each other during the heady days of LawTube. Probably in fact, it must have been, the Rittenhouse trial.
It could be. I don't remember exactly when we started interacting, but it's just endless. I just cover, it never ends. So I'm always covering one trial or another and interacting with people, but it's been quite a long time. Probably before that on Twitter, back when it was Twitter.
Could be. So Andrew, explain, it's a fascinating thing that you've done with your career and how you've swung out. You were a criminal defense lawyer?
Right.
Well,
I mean, I came out of law school and I didn't have any connections. Like, I didn't do an internship at a law firm. There's no lawyers in my family, so I had no in to anything. So I just hung up my shingle and started practicing law. I took all those courses that the bar offers for new lawyers and how to do drunk driving cases, how to do real estate closings, how to do everything. I was just doing everything.
Well, where were you?
I was in Boston at the time. So I went to law school in New York, and then I followed a girl to Boston, and then I was stuck there for 25 years. But
with her, though?
No, not with her. She didn't last very long. But
so
there was another woman, and then you know how that goes. So
okay.
But I was just doing everything. But I was, in addition to being a lawyer, I was a member of the gun community. I was a very active, competitive shooter. I would be at gun shows and gun stores and gun matches, and people would ask me these questions about use of force law, like, when am I allowed to shoot somebody? And I realized I didn't know the answers. Because I don't know about you, in my 3 years of law school, we spent maybe a few minutes on justification as a legal defense and first-year criminal law. That was it.
Yeah, that was it for me too.
And there weren't any good resources even for lawyers. When I wanted to learn what the law was for use of force in Massachusetts, I had to go to the law library, do primary legal research, read the case law, look at the jury instructions. And then when I did it for Massachusetts, you know, in the Northeast, a lot of those states are small. If you're in Massachusetts, you drive 30 minutes in any direction. Now you're in Vermont or New Hampshire, or Rhode Island, Connecticut. And I was in all those states routinely. I had concealed carry permits for all those states, and I didn't know the law. I'm walking around with a gun, and I didn't actually know when I would be permitted to use it. And I found that pretty frightening. So after I did the law in Massachusetts, I learned it for those other surrounding states. And I began to see a common pattern that the underlying principles of use of force law didn't vary those handful of states. And I wondered, could that be true of all 50 states? And I did the primary legal research on all 50 states. And it turns out it's basically the same body of law. It's about 80% the same. And of course, that's because use of force law is thousands of years old. I mean, it's as old as human beings, these rules around when you can use force against another person and have it be lawful. And because it was that common, that opened up the door for me to begin my practice of law in a way that's not common for lawyers, but to be a consulting attorney to other lawyers who are lead counsel across the nation in use of force cases.
And thereby is a career born. Although you said something that I don't want to leave untreated. I learned from I want to find the handbook.
If you go to lawofselfdefense.com/free book, because we give the book away for free.
Yeah, well, I want to both encourage people to get it as I have, but also throw it up there. And because one of the things I learned was that, it's true that compared to how little most of us know, there are some substantial differences that could make a difference in life or death, or your liberty, rather. But before I mention that, this is the free book, okay? lawofselfdefense.com, free book, and it forwards to this URL, and you get a book. Can you I want to hear you in your own voice say this. You carry a gun.
You carry a gun, so you're hard to kill. Know the law, so you're hard to convict.
Da-da-da-da. I mean, that's what it's all about, man. And but there really are differences from state to state, as it turns out, that even though the general principles, as you pointed out, if you don't crack the book, if you don't start looking into it, you won't have the slightest idea.
Right.
But there are things that can make a difference depending on what state you're in.
Yeah, so I say it's about 80% the same. Well, the 20% difference matters. The 20% difference is the difference between getting acquitted or convicted in that particular state court. So we also have a separate DVD online streamed course that for each of the 50 states that goes into that. I mean, guys, listen, 20%.
You really do have to go to this website, which I have in my professional capacity, had the opportunity to peruse in very great depth. This guy has got every single angle covered. Any possible monetization that might come from getting information out there has been considered and almost certainly exploited. But it really, I mean, is there anyone else out there who you can, if you were on trial,
right,
and you needed a consulting expert and it wasn't going to be, and you didn't want to use yourself because it's, a lawyer who represents himself as a fool for client, whom would you call?
Yeah, I'd have nobody to call because nobody does this. I mean, so
there are people who do this, but not as lawyers.
Well, criminal defense lawyers, of course, do self-defense cases, but most of their self-defense cases are, if you're a criminal defense lawyer, most of your clients are criminals. I mean, that's just the nature of the practice. And so they get a lot of self-defense cases, clients, where it's not really self-defense. That's just a legal defense they're raising because that's what you do as a criminal defense attorney. and those cases tend to be, I call those bad guy cases of self-defense. And they tend to be substantially different than good guy cases of self-defense. Someone like you or I was compelled to use force against another person. And if you ask a typical criminal defense lawyer, a 30-year career criminal defense lawyer, how many good guy cases of self-defense he's had come into his office, he'll say 4, 5, 6. That's it. They're just not that common. And you don't get very good at something or have the opportunity to cover all the angles of the law if you've only done 4 or 5 or 6 cases on it over a 30-year career. So what I really bring to the table is, I'm not lead counsel for anybody. I mean, I could be in the Commonwealth of Massachusetts. That's where my bar membership is. But I wouldn't do that. That's not my role. Someone has a lead counsel. That guy's handling the thousands of details about a criminal defense trial that don't have to do with the intricacies of use of force law. And what I bring in is a very in-depth expertise in that narrow silo of use of force law. Because otherwise they miss things. I mean, it happens all the time.
I'm sure you can rattle off some examples of some of these different state distinctions that could make a difference between acquittal or conviction or aggravating factors.
Oh, yeah, there's tons of them. I mean, the biggest difference among the 50 states is this issue of whether or not you have a legal duty to retreat before you can defend yourself. It's commonly called stand your ground. When the George Zimmerman trial was happening back in 2012 or 2013, Florida's a stand your ground law, and the media made it sound like this was some aberrant form of self-defense law that only Florida had, that they were weird to have this. 39 out of 50 states are stand your ground states, including states like California, where you might be surprised given its anti-gun politics. The legal duty to retreat is relatively uncommon. Only 11 states. They are states like New York and New Jersey, however. And where that duty exists, prosecutors love it because it's a very fertile ground. Because let me take a step back. For any claim of self-defense, there's up to 5 elements that have to be present for your claim of self-defense to be valid. Those are innocence, imminence, proportionality, avoidance, the duty to retreat in 11 states, and reasonableness. And these 5 elements are cumulative. The required elements are all required, which means from the prosecutor's perspective, his mission is to find one of those 5 and knock it out, disprove it beyond a reasonable doubt. And if he does that, it doesn't just diminish your claim of self-defense. Your claim of self-defense collapses. So those 5 elements are targets of attack for the prosecutor. In most states, they don't have the element of avoidance. They don't have the duty to retreat. So in those states, there's really only 4 elements, 4 targets of attack. In the duty to retreat states, they add avoidance in. It's the 5th element, and therefore a 5th target for attack for a prosecutor. So when you ask prosecutors, they love the duty to retreat because it makes their job easier. They have an additional element to attack. In the stand your ground states, you still have to argue the other 4 elements. You still have to be the innocent victim of aggression. You still have to not be using disproportional force. You have to be defending yourself against a threat that's happening right now. You have to have conducted yourself in a reasonable manner. If you do all that, you're good to go. That's self-defense. They don't require that you also adhere to a 5th requirement of that element of avoidance. That's the biggest variance. Now, there's lots of other variances, of course. In some states, for example, if someone is forcibly entering your car while you're in it, they treat it like your home. In fact, they create a legal presumption that you're entitled to use deadly force against that person. Other states don't have that kind of provision. If you're in your car and you're attacked, it's just as if you were on the street. It's a straight up self-defense analysis. So these wrinkles across self-defense law can make a huge difference in the defense. I worked on a case once where a homeowner had invited a garage door repairman to fix his garage door, and they got into a dispute about payment or something. I forget what it was. The homeowner got scared, and he reached into his car in the garage, took a gun out of the glove compartment, and the other guy started going crazy, just walking around, screaming, yelling. But as he was walking around, he actually walked out of the garage and then came back into the garage. Well, that created a very interesting wrinkle because when that guy first entered the homeowner's house, it was with permission. He was invited in to make a repair. When he wandered out of the garage and then back in, he was now an unlawful trespasser in the home. Completely changed the defense narrative for the homeowner, and we got him acquitted.
Cool. Now, how much does training in the use of guns align with the educational goal here? In other words, I imagine, the criminal defendant who is asserting the right of self-defense, I imagine that the way these factors apply could be affected by his level of training or experience.
Well, I mean, certainly I would expect
reasonableness for me and reasonableness for you. I've never held a gun in my life. Reasonableness for you, an experienced shooter, might be different. I don't know.
It could be on the tactical edge. What reasonableness is really asking for is 2 things. Did you have a genuine good faith subjective belief in the need to act in self-defense? I mean, if you didn't think it was self-defense, it can't be self-defense, right? But also that belief has to be objectively reasonable. A hypothetical, reasonable, and prudent person would have shared that subjective belief. So it can't be speculative. It can't be imaginative. It can't be based on bare fear. It has to be based on things you're observing, like you saw a gun in that other guy's hands, that informed your decision-making. That's what reasonableness means. It can come up in a very narrow sense, like a tactical sense of when you shot, how many times you shot, but not very often because most of the lawyers on the other side, the prosecutors too, they're not that sophisticated about this stuff either. Listen, they only got 3 minutes of self-defense law in law school too. Yeah. I mean, that's why we say, be hard to convict. We can make you hard to convict because the prosecutors aren't up on this law either.
And the vast majority of self-defense cases they encounter are the bad guy cases.
Yes, exactly right. So, and those
So
are very easy to defeat because they weren't genuine self-defense. So they're used to, it leads to a certain kind of bias because, of course, 99% of the self-defense cases that prosecutors see, that judges see come into a courtroom, they're bad guy cases of self-defense. So when you walk in and you're claiming self-defense, they immediately presume that you're in that category too. Why wouldn't they? We often encounter, in my practice, prosecutors are just shocked at the kind of defense that they're getting in a self-defense case because they're not accustomed to seeing that at all.
Are judges up to hearing it? Because they suffer from a lot of the same biases, obviously.
So it varies. So sometimes judges will take what I think is a perfectly reasonable position because I'm often asked to be like an expert witness at a trial for the defense, right? So take the witness stand, explain self-defense law to the jury. A lot of judges will take the position that, hey, I'm the expert in the law in this courtroom. I'll be instructing the jury. We don't need some other legal expert coming in here and talking about that. I think that's a mistake because that judge also only got 3 minutes of self-defense law in law school. And the jury instructions are not as comprehensive in any state as we would like them to be to cover all the wrinkles that can occur in a case. But I understand judges are they instruct the jury on the law. I can understand that position. I have had judges who've been much more generous. They're like, yeah, tell us all about it. Of course, they've seen my book. Normally, you go through voir dire first as an expert to qualify as an expert in the courtroom. I'm not shy. I'm very impressive on voir dire. I've never not been accepted as an expert in this area, as you might imagine. And I've had judges, I think it's almost crazy, but they'll let like defense counsel ask me one question and then they'll let me talk for 15 minutes. And that's not how it works, folks. That's not normal. Normally, it's a question, answer, question, answer, question, answer. And I've basically been able to testify my book into the jury's ears in the courtroom. And obviously, that's very efficacious for the defense.
You're allowed to actually, I imagine that objections come up along the lines of ultimate issue.
Yes. So what I cannot do as an expert witness is say this was self-defense. What I can say, and I tell the jury that, by the way, I tell the jury, listen, I'm not here to tell you whether or not this was self-defense. That's your job to determine whether or not this was self-defense. I'm here to explain to you the math equation of how you make that determination, what the elements are to get to that answer. But of course, if you let me define the equation, I'm pretty much defining, I know what the evidence is, right? So I'm pretty much defining what the answer is going to be. It's like if you're in a debate, right? I love doing debates. The best debates ever are when they let me speak first, because then I just frame the entire issue. And then they're screwed because now they have to argue within my frame. And I framed it so I would win.
Well, we see this on social media all the time, and you become much more of an active social media guy since well, let's just use scare quotes for now. The judicial coup of the last month or so has animated you quite a bit. But we're often responding, and I have this, of course, as one of the big anti-Semitism, enforcers, anti-Semitism enforcers on X. People set up these preposterous straw men,
right?
Framing is everything.
Yep.
Do you have much of an opportunity to give your courses or to instruct people in law enforcement or prosecutors as institutionally in any kind of way?
I mean, it's varied over time. So I've been accredited to teach CLE in, I think, 38 states. Every state we've ever applied, I've been accredited. So I've taught a lot of lawyers, prosecutors, police officers, but I don't do too much traveling anymore. There was, for many years,
I was motorcycle.
Except on my motorcycle, right? But for many years, I was traveling basically every weekend of the year to teach a CLE course or a civilian course somewhere in the country, 45 weeks a year, easily. And I did that for 7 or 8 years. And then before COVID, I probably would have quit at COVID anyway, but a couple of years before COVID, I just said, I don't want to do this anymore. So we put all our content on in a pre-recorded, video on demand kind of format so people can access it. And then twice a year, I teach a full day course online, just like this, like a web Zoom type course. But that's the only live teaching I do now. And I don't know who shows up to those. They just pay me money and they show up. So I would expect it would be a lot of lawyers and a lot of police officers as well as civilians.
What do you think? I mean, do you think the Rittenhouse trial resulted in more or less awareness of what the law really is?
Well,
Or did it just
I
distort the hell out of everything?
yeah, I think it just distorts. I mean, the trouble with trying to learn self-defense law from a self-defense case is every case only has a very narrow set of facts. So you're learning what might apply to those facts, maybe in depth, but you change one fact. Small changes in facts lead to very large changes in legal outcomes. So unless you understand kind of the foundations of how this works, you can't apply it generally. You've only acquired expertise. It's like if you only know how to cook one dish, but you don't really know how to cook, right?
I would, I have the impression that prosecutors are bringing more cases against good guys in self-defense scenarios today than was the case 20 years ago. Do you think that's right?
Yeah.
Daniel Perry, is it? Was that the guy in New York?
Daniel Penny was New York.
Right.
There was another guy, Daniel Perry, down in Texas, who shot a Antifa protester. So it's easy to get the cases mixed up. Well, yeah, because the drivers behind the prosecution are different, and the prosecutors are different. So 30 years ago, prosecutors were mostly, like they looked like me. They were old gray-haired guys in the legal community. They'd been doing this. Maybe they'd been the prosecutor in that district for 30 years. They've been doing it forever. And they just really, for the most part, made their typical sound decisions about what cases to bring to trial, which ones to settle, and so forth. It was boring.
They were professionals.
They were professionals. Now a lot of prosecutors are political activists. Politically signed into those jobs. I mean, we hear about all these George Soros funded prosecutors. That's all real, folks. That's not made up. These people are in that office to exercise political power. And George Soros is a clever guy. He's very good at this arbitrage and leverage stuff. He realized prosecutors have unbelievable power and authority and discretion in their offices, either to bring cases to trial or not bring cases to trial. And they are cheap to buy. Most prosecutor races, it's a couple people running, it's a few $1,000s they're spending. And if you drop $100,000 in campaign contributions on one of those candidates, you just bought that seat. And they can have tremendous influence on the politics in their environment. They can destroy an entire urban city simply by not enforcing criminal law. I mean, we see that time and time again. Or if someone resists criminal predation, they can selectively prosecute that person, like they did with Kyle Rittenhouse. There was nothing Kyle did that was inconsistent with use of force law. Absolutely nothing. Now, it was a poor judgment to, go into a place where there's going to be this tumultuous environment and therefore you need to bring a rifle with you to keep yourself safe. Yeah, if you were his dad, you would not have told him to do that, right? That's a high risk endeavor. Same with George Zimmerman. There was nothing George Zimmerman did that was inconsistent with self-defense. I remember I got the complete evidence file in that case before it went to trial, and I said to myself, well, there must be something in the evidence that the prosecutor is seeing that's inconsistent with self-defense. And I looked through thousands of documents and photographs, and there was nothing. But they prosecuted him anyway for purely political purposes. It becomes a win-win for the prosecutor. So in the George Zimmerman case, for example, that prosecutor wasn't even the prosecutor in that district. She was from Jacksonville, the other side of Florida. The prosecutor in that district refused to charge Zimmerman. He said, I'm looking at the evidence. It's clear-cut self-defense. He resigned rather than bring charges against Zimmerman under tremendous political pressure. That let him bring in Angela Corey from Jacksonville. She was happy to prosecute Zimmerman because Zimmerman, of course, had shot Trayvon Martin, a young black male. And Angela Corey was in big trouble running for re-election for her prosecutor seat. She was going to lose. She had prosecuted some black people in her community that were very unpopular cases. There were protests led by Al Sharpton in her district. She was going to get wiped out in that election. But she saw a political opportunity. I can go after this George Zimmerman guy who shot Trayvon Martin, and I will be a hero in the black community. And I will get reelected. And she was absolutely right. And people look at that acquittal of George Zimmerman, and you might think, well, the prosecutor lost there, huh? No, because she didn't care about winning the case. She cared about winning re-election. And in that context, the proper political context for her framework, she won. That was a victory. She won re-election. So that's how a lot of these decisions are getting made now, especially if there's any kind of racial component. a white defender and a black victim, then you get Al Sharpton, you get all these guys come into the mix, and the politics gets super energized. And for the prosecutor, it's a win-win, right? If she had convicted Zimmerman, she would have said, see, I told you he was guilty all along. But she didn't convict him, and she still won because she won her reelection. So there's no downside to these prosecutors bringing these politically energized cases to trial.
Especially because they're not spending their own money.
Right.
I mean, as a civil litigator, I'm always trying to do some kind of guess at what my adversary's appetite is for spending money on a case.
Yep.
And it informs his tactics and mine. But when you're dealing with the state, it's not so much. I think these cases, not only are they informed by political forces, but they also accelerate the political forces. And so George Zimmerman and Kyle Rittenhouse are tropes on the left,
right,
of people who were unjustly allowed to walk after murdering someone who just so happened to also be trying to murder them.
Yep, that's right. Yeah, like George Zimmerman, he could never have a normal life. I mean, I didn't know George Zimmerman at the time of his trial, but I've come to know him since. And it was about a decade before he was kind of normal again. I mean, this kid, he suffered horrific PTSD. He wanted to be a lawyer himself. He wanted to be a cop when all this happened, when all this went down, when he volunteered for his Neighborhood Watch program because he cared about his neighborhood. They interviewed every person that lived in that apartment complex with him, which was very racially diverse. So they interviewed the FBI came in with like 30 agents. They were looking for any kind of racial animus on the part of George Zimmerman here. And everybody in that apartment complex loved George Zimmerman. They knew him because he would stop his car in the street and help you bring in groceries. If your apartment got robbed, and there were a lot of robberies in this community, he would help you put a new lock on your door. This was for everybody. They interviewed black residents, white residents. Everybody loved George Zimmerman.
How about white adjacent Latino residents?
I don't remember.
Remember George Zimmerman? He's a Hispanic guy, right?
White Hispanic. Yeah, that was the first time I ever heard that phrase.
with his mother's last name.
His mother's Panamanian and looks extremely Panamanian. She doesn't look white. His family had homeschooled. Like after school, the black kids in the neighborhood would come to his house to do homework. So his mother could help them with their homework. I mean, he led a protest. A black kid in the neighborhood was beat up by the cops, and he led an anti-police protest in defense of his friend who was beat up, his black friend who was beat up. There was not a drop of racial animus in this kid's body.
It doesn't really matter because everything is symbolic.
It's all a narrative. It's all storytelling. I mean, you know this, of course, but once you get into court, you're telling stories. Right. The jury doesn't know what happened. They weren't there. They don't have any if they had any personal knowledge, they wouldn't be on the jury, right? They're a blank slate. And all they know is they're being told a story of guilt by the prosecutor, and they're being told a story of innocence by the defense. And they have to decide which story they believe. In theory, the state has to prove guilt beyond a reasonable doubt. That's nonsense. It's really a preponderance standard that these juries are applying. Partly because the defense is not very good at drilling in what it means to be guilty beyond a reasonable doubt. But the jury's just hearing stories.
Evidence standards. I mean, look at these TROs that are coming out now in these Trump cases. You're supposed to show a likelihood of success on the merits,
right?
Which means both legally and factually. These people, these judges are just winging it. I mean, preponderance of evidence. People just, work up an affidavit and they go where they want to go.
I mean, it couldn't be more clear cut, honestly. I mean, if we just take a step back and look at all this stuff from like a 30,000 foot view, we're really looking at like three major categories of these cases now. One is the money laundering cases, I'll call them, the USAID type cases where Trump turned off the money flow and all these people want their money, right? That's one group. Another group is the firing cases, right? All these people have been fired and they want their jobs back. And now with the third case, I'll call the military cases, right? The trans guys have to be allowed back into the military. In all of these, clearly federal district court is not the appropriate venue for any of these. In the money cases, There's a place to go if you believe the government owes you money for services rendered. You go to the court of claims. Congress set that up specifically so those cases would not end up in district court. For the work cases, there's a civil service process, administrative process you go to if you feel you've been wrongly terminated, set up specifically so those cases would not end up in district court. And in the military cases, where is the president's Article 2 authority greater as the commander-in-chief than in the military context? The notion that any of these cases are likely to win on the merits is nonsense. In fact, these courts don't even have jurisdiction over these cases.
It is really something to see. And the problem here is, I mean, the problem is the whole thing's a problem. Did you see the one that came out yesterday on the trans case in California? The judge cited to the Hamilton musical. Did you see that?
Another one of these judges quoted Taylor Swift in a footnote.
So, that has been a little bit of a trend over the last 20 years where clerks sneak in. I remember one of the early ones of these was a bunch of Talking Heads lyrics for subtitles of sections. So here we go. Yeah, this is now so far beyond. Okay, share. Okay, so this is that California case, and the footnote is number 5. And Omena created, the court's opinion is long. I think this was 91 pages. The court's opinion is long, but its premise is simple. In the self-evident truth that all people are created equal, all means all. Nothing more and certainly nothing less. You already know what you're in for here. Okay. Footnote, for all people are created equal. You might think that the simple approach to this would be if you really want to get on your soapbox and go rhetorical, to cite to the Declaration of Independence, right?
Indeed.
No. Here's what the footnote says, folks. Women were included. See bottom of the 5 there. Women were included in the sequel. Included in the sequel? What the hell does that mean? All men are created equal, included in the sequel. I guess it rhymes. When passage of the 19th Amendment granted him the right to vote. See Lin-Manuel Miranda, Hamilton, an American musical. Compare. In other words, compare. Folks,
I think they're on the same level.
The compare reference in Blue Book in legal citation form. Compare U.S. Declaration of Independence with U.S. Constitution Amendment. This judge is telling us that Hamilton is the source. Okay, you get it, folks.
And I'm just saying a lot of bad reasoning from a lot of these judges. We have this judge, Ali Amir, the Canadian-born judge, just put on the bench last November after the election. And, of course, there's lots of reasons, things you can raise and critique, like he's born in Canada, right, not the United States.
And I think he practiced law in Canada until, a short time before he... I
think he was on a Canadian court. I had heard he was on some kind of Canadian court.
Jesus Christ.
And I think this guy went to Harvard Law School. But when I read his orders, they're just not well thought out. This is not a keen legal mind that drafted these things. They're not well structured. They're not clear. There's no clarity on exactly what is being enjoined and not being enjoined. It's like a hot swamp of things he's unhappy about. That, and of course, a key facet of an injunction is supposed to be absolute clarity on what you're allowed to do and not allowed to do, or are supposed to be doing. Otherwise, how do you know?
This is actually in the rule that authorizes courts to issue injunctions in civil cases. The rule explicitly, as Andrew's saying, the rule explicitly says just how specific and narrowly tailored the relief has to be. All these rules. The only thing I ever taught in law school was a course on remedies. All these rules, these are all supposed to be an extraordinary remedy. All out the window.
They're handed out like candy on Halloween now.
Oh, actually, okay. So I'm gonna. It really is, and it's something I noticed myself a while ago. I mean, it is true. Listen, I did a lot of intellectual property law, and until fairly recently. And if you represented a major brand and you had a registered trademark, you could go into the Southern District of New York and get a preliminary injunction just by showing up. And that usually made sense, but it didn't always make sense. And there were certain formulas that judges could, and I mean, that lawyers knew were always worked with judges. I mean, one of the problems, of course, is that so many of these judges never practiced law or never practiced they were never in private practice. And this is something as a criminal defense lawyer, prosecutors are different kinds of lawyers from other people.
I think so. I think as a criminal defense attorney, I would say that me and my peers are generally better than the prosecutors because we have to be. Because again, most of your clients in the criminal defense, most of your clients are criminals. And the prosecutors are just grinding their handle on their machine and getting conviction after conviction, getting plea deal. They're just not. It's not as intellectually demanding as being on the other side with the criminal defense client and a lot of evidence and witnesses against them.
So now, I mean, I used to say 20, 15 years ago, I would say it has become so relatively unattractive financially to become a judge, even though federal judges do okay, but they don't do as well as very successful lawyers of the same level of seniority, and especially in metropolitan areas, that a lot of the federal judges increasingly were former prosecutors who saw they were never going to be named as a U.S. attorney, which is, the ultimate plum for a prosecutor in a federal office. They would become judges. What we're seeing, we especially saw in that, the last year of Biden, these people weren't even prosecutors. These are people who have never stepped into a courtroom. They're basically, the community organizer level of law graduates.
Yeah, like Barack Obama was a lawyer. All right.
I don't want to talk about too much about the Trump stuff because I'm predicting that when this comes out, it's going to be resolved. It's going to be resolved by the Supreme Court, and everyone's unhappy right now because it isn't for two reasons. One I think is a bad one, and one I think is not a good is a good one. Bad one is it's happening now, and the problem is and we want results now, and it's like a cancer. It's spreading. That's not a really good reason. If in fact the normal course of appeals will resolve these issues, we can live with it. But the problem that even people like Mike Davis, who tends to be really careful and who lost it this week, is the reason we're here is because of all the restraint, all the perfect being the enemy of the good. And it's really undermining the credibility of the judiciary. I have got a feeling you probably would agree with that second argument.
I mean, I do. To my eye, these are all blatantly political decisions being made by these judges. They're committing gross violations of the separation of powers doctrine. Like I talked about before, there's basically three categories of these cases: the money cases, the firing cases, the military cases. The plaintiffs have no leg to stand on to be in district court on any of these. The judges should recognize that. So they're acting politically. And by the way, you say judges don't get paid that much, and that's true, but they found other ways to supplement their income. I mean, if you look at these judges, and I haven't done a thorough investigation, I'm not a private investigator, but the times I look at these judges, I'm like, I wonder what this judge's wife does for a living. They all work for NGOs. Their adult children work for NGOs. They're all part of this money laundering machine. And these judges, they're horrifically conflicted. On a personal level, their personal finances are being negatively impacted by the policies that Trump is advocating for. And those judges, there is a code of conduct for United States judges that's not imposed on them by any other branch. They devised this by themselves. They have to be diligent, impartial, unbiased, not even the appearance of impropriety. These judges are violating all those rules. So yes, I think these judges it's facially true that they're acting inappropriately. At the same time, I can see the wisdom in the strategy that Trump is pursuing. I think Trump would be entirely within his constitutional authority to point at some of these injunctions and say, you don't have the authority to do that to me. The Article 2 executive branch elected president. You just don't have the authority. This has no more lawful authority over me than if a third grader drew out an injunction in crayon and sent it to my office. It's simply valueless. It's ultra vires. But he's not doing that. He's saying, all right, I think it's BS, but let's go with the process. Let's go to the Court of Appeals. Let's go to the Supreme Court. Let's see how it flows. Because the best outcome is he wins consistent with the legal process. If that can be done in a sufficiently timely manner. It's still only been a couple months, folks. 2 months now, right? So if this is still going on in 9 months, then we have a serious problem. Then
no, I believe that it won't be. I believe that it will. My prediction on X was that by the time the cherry blossoms are blooming in Washington, which might be a little bit sooner than I want to think, but I think it's going to be resolved in a couple of weeks. Well, Andrew, you and I could schmooze about this stuff all day. The problem, it's going to lose its currency. You have found yourself a very interesting little perch. You've done a great job of becoming the man on the topic of the law of self-defense. Do you think anything's going to change before you hang up your spurs in your area of practice, whether it's culturally or, big picture legally, or is it just going to be more of the same?
I think things change around the margins with self-defense law. The principles are so well established that they can't really change. But the biggest change I've seen is more states becoming stand your ground. They had a duty to retreat. They got rid of it. They're stand your ground states. I'd say in the last 20, 30 years, maybe that's been true of 10 or 15 states have gone in that direction.
Really?
No state has gone to adopt a duty to retreat.
So what's driving that?
Because people were being convicted on the grounds that the prosecutor argued to the jury. Because this is what a prosecutor will do. Say you're in a shopping mall and someone comes at you with a knife and you shoot them in lawful self-defense. The prosecutor will put up like a little schematic of the shopping mall with 100 little red arrows leading out. And the prosecutor will say, well, maybe this would not be a safe avenue of retreat, or maybe not that one either. But of these 100, certainly one of them must have been a safe avenue of retreat, and therefore this defendant failed to take advantage of it, loses the legal defense of self-defense, and you must convict. And people were getting convicted on that basis. The truth is, this issue of retreat should never be on the table. One of the other elements of self-defense is the threat you're defending yourself against is imminent. It's not a past threat. That would be vengeance. It's not a speculative future threat that may never happen. You're defending yourself against a threat that's happening right now. And if we're talking using a gun in self-defense, it has to be a deadly force threat that's happening right now. If that's the case, how do you possibly have a safe avenue of retreat? I mean, you just have to defend yourself in that moment. So,
in other words, turning and running means he'll shoot you in the back.
Right, exactly right. So I think, especially with more concealed carry in the nation. When I started carrying a gun as a civilian, it was 1990, I don't know, 2 or 3 or something. And there was only a handful of states in the whole nation that had provision for concealed carry. Now every state technically has some provision for concealed carry. Some states like New York and New Jersey still make it very complicated. More than half the states are constitutional carry. You don't need a permit to carry a gun on your person. So I think with so many more people carrying guns, they start paying more attention to what the liabilities might be if they ever have to use it. They hear about people getting convicted because the prosecutor says they could have possibly retreated. They're like, no, that's BS. I don't like the sound of that. And they call their legislatures and they get their legislatures to get rid of that duty to retreat law.
Wouldn't it make more sense to just get prosecutors to get their heads on straight? Well, as you described earlier, though, prosecutors are now part of a political process in a way that they weren't outside of a couple of, well-known areas.
And people have to understand, you know, if you've used force to defend yourself, you know you were in a fight, you defended yourself. But when you go into court, all those other people in court, they're not seeing you through your eyes. They're seeing you through their eyes, and they have different interests and different motivators. I've seen people brought to trial on felony charges essentially just because they had a new prosecutor in the office who hadn't done a felony case yet, and they were going to give him you to be the test subject. Because it didn't really matter if you lost the case or not. They needed him to get some chops in. You know, from that office's perspective, that was a pragmatic way of using that prosecutor.
How do you go to sleep at night?
They don't see you as human. You're not a human being. You're just, it's like a psychopath, right? A psychopath lives in the world, but all the other humans are not human to him. They're just like cartoon characters. The only real human is him. Prosecutors become like this, and in part because they spend their whole careers dealing with criminals, right? And so they stop seeing these people as real. These people are the murderers and the robbers and the people who do bad things to other people. I see prosecutors, I swear, if they could go into court wearing a Batman outfit, they would. I mean, that's how they see themselves. They are doing God's work. And so if you believe that, then the ends always justify the means.
And on that note, we're at an end, and I means it. Guys, Andrew, great hanging out. Thank you very much.
Always a pleasure. Always happy to be here, Ron.